Thank you so much for being here. Welcome to IPI. Good morning or good afternoon to everyone who's joining us in person or online. My name is Jenna Russo. I'm the Director of Research here at IPI and the head of the Brian Urquhart Center for Peace Operations. We're very pleased to welcome you today for our policy forum on accountability for crimes against peacekeepers. Today's event launches one of the first independent reports on this topic, which unfortunately remains a critical concern within peacekeeping. The number of malicious attacks against UN personnel in peacekeeping contexts has increased since 2013, with an average of 30 uniformed staff killed every year in the Central African Republic, Mali, and the DRC. The issue of safety and security of peacekeepers has become a matter of priority for the UN Secretariat and for member states, as reflected in Action for Peacekeeping. And incrementally, the larger question of accountability to peacekeepers has emerged, which includes pursuing justice for crimes against peacekeepers, as reflected in Action for Peacekeeping Plus. However, the overall complexity of peacekeeping in contexts not only compounds the risk to peacekeeper safety and security, but has also, in many cases, made it more difficult to render justice for crimes committed against them. Today's event will discuss both challenges and opportunities for pursuing accountability for crimes against peacekeepers. The session will be moderated by IPI Senior Policy Analyst, Agathe Sarfati, who is also the author of the report. This report and today's event is part of IPI's broader stream of work on Action for Peacekeeping Plus, and we would like to thank in particular the Kingdom of the Netherlands for their continued partnership and their generous support on this project. Before turning the floor to Agathe and our panelists, I would like to first welcome Jehoen Oostervaar, who is the Deputy Head of Political Affairs for the Permanent Mission of the Kingdom of the Netherlands to the UN, to provide some opening remarks. Jehoen.
Good morning, everyone. Good morning, Jenna. Wonderful to be here again. It's really an honor to be here and to be able to help welcome all of the participants at this forum today, and to be in the company of very distinguished panelists that represent the UN, both HQ and online, from the field, academia, fellow member state, a representative from a very active country as a troop contributing country, and a country that's active on this specific topic. The Netherlands really appreciates the cooperation we have with IPI and our engagement together on very important topical issues. The IPI really manages to address some of the most complex topics and help us all to engage in a meaningful discussion about that. And this project and this paper is also meant to help the Secretariat and colleagues in the field to better and more effectively implement the A4P and A4P plus priorities. It also helps to provide a space to gather all relevant stakeholders, as it is done today, in order to build a common understanding of A4P plus priorities, and ultimately with the aim of helping to determine a clear path forward in the implementation. Peacekeepers and peacekeeping are vital to the United Nations and the whole international community and its efforts to maintain international peace and security. And peacekeeping remains really one of the most emblematic and symbolic roles of the UN. It's that role that still resonates mostly with millions of people around the world, and especially in countries affected by conflict. At the same time, it's very clear that peacekeeping and peacekeepers today face many challenges that undermine their ability to deliver their mandates. Complex threats in the operating environment, and they are causing a rise in fatalities, in injuries amongst peacekeepers, and peacekeeping missions often lack the tools, the equipment, and personnel to meet those mounting security challenges. And as the excellent paper by IPI notes, sadly, since 1948, more than 1,000 UN personnel have been killed in malicious acts while serving in UN peacekeeping operations. And most of the recent fatalities take place in Central African Republic, Mali, and the DRC, and we'll hear from the field about the context there. This means that more than 1,000 people really paid the ultimate price for the principles and values and ideas of the UN, for the blue flag that symbolizes hope and pursuit of peace. And it's particularly worrying that today there is an increasing danger to peacekeepers because of new threats, new challenges, those emanating and coming from also acts of disinformation, misinformation, and hate speech against UN missions, UN peacekeepers. And there are many reasons why to focus on this topic today. And actually, the key reasons are very simple. The more dangerous the environments are for peacekeepers, the less likely that it will be possible to do adequate patrolling, monitoring, and deconfliction. The less presence and deconfliction there is of peacekeepers, the more strain there will be on UN peacekeeping and UN presence in general. And if peacekeepers face increasing security challenges and restrictions of movement, this will affect the work and operations of the civilian components, as well as of humanitarian aid access and delivery. To address these serious challenges, as part of A4P+, UN Secretariat has focused on improving the safety and security of peacekeepers and advancing accountability for crimes against peacekeepers. And we really commend the UN for all of the efforts in that direction on the strategic, operational, and institutional levels. But as the paper also notes very clearly, there is still room for progress. And the paper provides already some recommendations and some direction for this discussion today. Recommendations to the UN Secretariat, to UN peacekeeping operations, to the Security Council, to UN membership, a larger UN membership. So I'm pleased to see a lot of interest today for this topic. Pleased to see both online and offline presence and a very good number. This proves that this topic is important, and countries and colleagues attach a lot of importance to this topic. So without further ado, let me also emphasize that we, my colleagues, I'm here not alone, other colleagues from the Dutch mission as well, are looking forward to this discussion today. We'll look forward to learning from you and from your insights. And of course, we look forward to keeping up the discussion on this important topic. Thank you so much.
Thank you very much, Jehoon. Thank you very much, Jenna. And thank you very much to the Netherlands for supporting this work and giving IPI the opportunity to shed light on crimes against peacekeepers and recommendations to advance accountability for these crimes. Violence against peacekeepers is not a new phenomenon. Since 1948, and it has been mentioned already, over 1,100 peacekeepers have lost their lives in malicious acts. The notion of justice for these crimes is not new either, since it is at the heart of the 1994 Convention on the Safety of UN and Associated Personnel, and this is also an obligation set out in the Status of Force Agreement concluding between host governments and peacekeeping missions. Despite these frameworks in place, not only crimes against peacekeepers continue rising, but the contrast between the numbers of fatalities and the number of prosecutions is striking. Since 2013, over 250 peacekeepers were killed in the DRC, Mali, and the Central African Republic, but only 8 trials were conducted in relation to these crimes. The UN Secretariat, TCCs have thus called for more political attention to the issues, and recently there has been a prioritization of accountability for crimes against peacekeepers. And this is against this backdrop that I conducted the research for the paper we are launching today. For this paper, I interviewed over 50 colleagues from the UN Secretariat, UN missions, UN Security Council members, troop contributing countries, host states representatives, as well as legal experts, to take stock of the progress, but also of the different strategic, operational, and institutional challenges, and propose concrete recommendations to move this issue forward. Today, we will discuss all these points with our excellent panelists, and we're lucky to have with us representatives from different constituencies. We have Stéphane Jean, on my right, from the UN Department of Peace Operations, Office of Rule of Law and Security Institution, or ROLSI. We have Colonel Ashish Bala, military advisor of the Permanent Mission of India to the UN. And online, we have Rafiq Maamar, who is the head of criminal investigation at MINUSCA, joining us from Bangui. We also have Ahmed Ghanem Ali, calling in from Bamako, who is the chief of the Justice and Corrections section of MINUSMA. And last but not least, we have Mona Ali Khalil, a renowned international lawyer, affiliate of the Harvard Law School Program of International Law and Armed Conflict, and a former UN senior legal officer. And in addition to our panel, I know we have a lot of strong expertise and experience in the audience, again, both online and in person. And I'll encourage you to share your questions and comments with us during the Q&A portion. But with that, I'll turn to our panel. We're going to start with Stéphane Jean. Stéphane, you are a judicial officer and coordinator in All-Road CDPO. In this capacity, you coordinate support in the areas of police, justice, corrections, and community violence reduction, in particular to the United Nations Integrated Office in Haiti. But in addition to these functions, you are the focal point for accountability for crimes committed against peacekeepers at UNHQ. You have been spearheading all the efforts from HQ in recent years, and we're lucky to have you here with us today to give us some background on what the Secretariat has done so far, share your assessment, and the way forward on the issue. Over to you, Stéphane. Thank you.
Thank you very much, Agathe. Thank you very much to IPI, as well as the Kingdom of the Netherlands, for hosting this important and quite timely event today. So on behalf of the Department of Peace Operation, I would just like to deliver a very short presentation providing an overview on the issue of accountability for crimes against peacekeepers. So as mentioned previously by the presenters, more than 1,000 of our colleagues have paid the ultimate sacrifice serving under the UN flag. Several thousand others were injured. Between 2013 and 2020, there were no convictions in those priority countries, namely CAR, Central African Republic, the Democratic Republic of the Congo, as well as Mali, for these crimes. A landmark moment, I would say, in terms of our approach to this issue has been the issuance of the Santos Cruz report in 2017, and I know many of you are familiar with that. And one of the key things in that report, from our perspective, is a recognition, and I quoted it here on the presentation, that there is a direct link between the failure to implement operation, to hold attackers to account, and fatalities, which means impunity in itself may act as a driver of instability, certainly, but may act also as a driver for fatalities, and therefore put our missions at risk beyond, of course, the key rule of law, justice, and other principle, norms, and standards that are associated with this issue of impunity, really. Therefore, there was a decision of the Secretariat starting in 2018 to have an increased focus on this issue. Now, you will see here a very brief quote from the Security Council Resolution 2589, again, a landmark report. This resolution was adopted in 2021 under the presidency of India. And really, there's a call upon member states, particularly those hosting those operations, to take all appropriate measures, essentially to bring these perpetrators of these crimes to justice. This resolution was unanimously adopted by the Council and co-sponsored by 84 member states. There are some key aspects also in that resolution. I won't go through all of them here, but promoting accountability at the national level, collaboration between host states and peacekeeping operation, the need also to strengthen the rule of law, the criminal justice chain, meaning police, national police, justice, and correction institution, as well as enhancing support for investigation and prosecution measures. The resolution also called for the establishment of a comprehensive online database on crimes against peacekeepers, and I can come back to that if needed during the question and answer session, but this should be launched actually in the first half of this year. In addition, there's a clear commitment from 2018 as part of the Declaration on Shared Commitments from more than 150 member states on this issue of accountability and bringing those responsible for these crimes to justice. We have also internally developed what we call the A4P plus agenda with very specific results as well as deliverable on the issue of crimes against peacekeepers. So we're essentially measuring progress against these standards. And these documents, by the way, are available also online, and we'll be quite happy to share the links as needed. There is also a group of friends to promote accountability for crimes against peacekeepers, which was launched in December last year. And my good friend Ashish will discuss in much more detail in terms of these parameters there and what the group intends to do and work over the coming months and years. Now, I will just elaborate a little bit more here in terms of actions from the Secretariat and what we have been doing in terms of moving forward with this issue. As I did mention, between 2013 and essentially 2020, there were no convictions. And we need to be honest here, there was not that much focus earlier, certainly prior to the Santos Cruz report, in terms of ensuring accountability for these crimes. So now we have this new priority. So we are focusing on this, and we've done a certain number of actions, particularly guidance to our field mission, the adoption in 2020 of standard operating procedure on the prevention, investigation, and prosecution of crimes against peacekeepers. This document is also available online if you are interested. We have also been coordinating a working group on accountability for these serious crimes against peacekeepers, which include our department, the Department of Peace Operation, as well as the Department of Operational Support, the UN Department of Safety and Security, the Office of the High Commissioner for Human Rights, and I'm pleased to see a colleague from OHCHR today, as well as the Office of Legal Affairs and our missions, MINUSCA, MINUSMA, MONUSCO, given that these missions were the ones that were the most affected by this phenomenon. We've also engaged extensively with member states, particularly TCCs as well as PCCs, meaning troop contributing countries and police contributing countries. And as I mentioned earlier, we have advanced in the development of a database, as well as a strategic plan, which we hope to have issued in the coming weeks. We can see also, I just want to give an overview here because our colleagues from the mission will discuss about that, but really there has been progress since 2018 in terms of the alleged numbers of perpetrators that were identified, alleged perpetrators detained, as well as confirmed investigative measures and the three priority countries. So we can see definitely, looking just at the data, the results of the efforts from the Secretariat and those missions in dealing with this phenomenon. Impunity, however, remains a challenge, as was mentioned earlier by my colleague Agathe. There have been few convictions. However, I would emphasize that we went from essentially 0 to more than 70 convictions in a space of about 3 years. So a lot of challenges, but at the same time, this corresponds to about 8% of such cases for the 3 priority missions. Now, in terms of next steps, and this is reflected in our forthcoming strategic action plan, we are looking essentially at 4 parameters, 5 parameters. One is political advocacy and information sharing, particularly in our engagement, continue our engagement with host countries, as well as TCCs, PCCs, the group of friends, and moving this issue forward, and also exchanging lessons learned across missions. Secondly, reinforcing support to host countries, because quite often, those countries do not have the technical and operational means to conduct investigation and prosecution. So that means assistance in terms of, for example, forensic, in terms of logistics, in terms of transport. So helping them to build that capacity to investigate and prosecute these crimes. And I should add here something quite important, namely that those that are responsible for killing and maiming our colleagues in those contexts are also the same, quite often the same, that are victimizing the civilian population. So in a way, this is a dual objective. It's not just protection of peacekeepers or ensuring accountability for peacekeepers, but it's also part of our agenda to protect civilians. We are also developing the comprehensive online database as requested under Security Council Resolution 2589. We will support the group of friends as the secretariat of that group, and we will also undertake a certain number of public information initiatives. In some ways, of course, our presence today is part of that, but we will definitely be doing much, much more of that. And in fine, I should add that really political, financial, and technical support from member states is absolutely critical if we want to continue to have the result that we've had in the past and to address the challenges that are facing us. Thank you.
Thank you very much, Stéphane, for really underlining the progress that has been made in just the past 5 years. And there is no doubt that all the institutional initiatives that are on the way will contribute to further advance accountability for the crimes. Thank you. We'll now turn to Colonel Bala. Colonel Bala, you have over 25 years of experience in the Indian military, including service serving as a military observer in what was MONUC at the time, and you joined the permanent mission of India as the military advisor when India was on the Security Council in 2021. Your country, India, is not only one of the largest TCCs deployed in peacekeeping, but India has also been a champion on accountability for these crimes in presenting the resolution 2589, which was adopted under its presidency, and also in supporting the creation of the group of friends on accountability for crimes against peacekeepers. So Colonel, we really love to hear like the TCC's perspective and really what you hope, what you believe should be done to continue advance this issue forward. Thank you.
Thank you, Agathe. Thank you, Netherlands, IPI, for organizing this event. Like our senior analyst said, I'll approach the issue from a TCC perspective. As my friend Stefan mentioned, more than 1,000 peacekeepers have lost their lives to malicious acts since the last 7 decades, and a disproportionately high number since 2013. This is because in recent years, the security environment of peacekeeping operations has become more violent, more riskier. Contemporary peacekeeping missions are dealing with conflict in which terrorists and armed groups are significant actors. They are not bound by the moral codes of nation states and view civilians and peacekeepers alike as legitimate targets. India has contributed more than 260,000 peacekeepers over the last 7 decades, cumulatively the largest number amongst member states. 177 of our peacekeepers have fallen while wearing the blue helmet, again, the highest number of casualties borne by any member state. We firmly believe that administering justice to perpetrators of crimes against peacekeepers will remove impunity and dissuade others from indulging in such crimes. It was with this belief that we piloted the Security Council Resolution 2589, which both Stefan and Agathe had mentioned in August 2021. As one of the foremost TCCs with more than 6,000 troops in 9 out of 12 missions, we take a close interest in the issue of accountability. And we insist that the aspect be reported in detail during the Secretary General's reports on various missions. However, we also understand that promoting accountability is not a simple issue. In fact, sometimes it is rather difficult to put into practice. Our peacekeepers serve in remote areas. Often, state rule of law does not extend to such areas. Many times, it is difficult to identify perpetrators or to even start judicial proceedings in time. An entirely different set of problems attends crimes in urban settings where masses or crowds are involved. Here, it is difficult to single out an instigator or a perpetrator for judicial proceedings. Host states have social and political complications. At times, there is lack of political will to bring perpetrators to justice. And even when host states have the political will, they may lack the technical expertise or the wherewithal to ensure accountability. Till recently, accountability was not a high priority for missions. It is only in the last 5 years or so that missions have started giving precedence, and actually results have started coming in over the last 2 to 3 years. Missions are not optimally configured for pursuing accountability. Though the resolution calls for dedicated focal points, in most cases, accountability is an additional task that has been given to existing appointments over and above their existing tasks. In fact, only 3 missions have nominated focal points for accountability. The other missions are yet to even nominate such focal points. Troop contributing countries do not have any intrinsic capability to either launch investigations for crimes or interact with the local law and order agencies, which are supposed to pursue these crimes. They must go through the mission focal points, but our experience is that sometimes TCCs do not even know about these focal points. They are not aware of their existence also. As on date, amongst TCCs, we do not have a clear mechanism to interact with each other and learn from each other on the issue of accountability. We need to have a mechanism so that we can standardize a course of action in case of such eventualities. So to promote accountability for crimes against peacekeepers, first and foremost, like Stefan also brought out, we need to support the rule of law institutions of host states to make them capable of promoting accountability. Assured and predictable mechanisms for capacity building are critical in this regard. Secretariat also needs to explore the feasibility of enabling TCCs to work with host states in carrying out investigations and following up on crimes against peacekeepers. The issue of accountability has to be brought to notice and given priority in mission mandates and mission configurations and taskings. In December 2022, like Stefan mentioned, 38 member states launched a group of friends for promoting accountability for crimes against peacekeepers to address some of these issues. It is a rich group. It has Security Council members. It has troop and police contributing countries. It has finance contributing countries, and it has some former host states as well. The group can act in tandem with the Secretariat and other stakeholders to identify shortcomings preventing accountability and harmonize needs and capacities in terms of expertise, resources, and training to address these shortcomings. The group can serve as a platform for sharing good practices and lessons learned by individual states. It can give impetus to promotion of accountability through inclusion in mission mandates, and it can share information and create awareness about accountability through various media and fora, including platforms like those provided by Netherlands and IPA right here. In short, the group of friends working in concert with the Secretariat and other stakeholders has the potential to make a difference in promoting accountability for crimes against peacekeepers. I will conclude here, ladies and gentlemen, and thank you for your patient hearing. Thank you.
Thank you very much, Colonel. Thank you very much for sharing the TCC's experience. It's very interesting to hear kind of this experience about the fact that sometimes there is this feeling that there is it's unclear who is the focal point at Secretariat, at the mission, and also you call for this need for a stronger coordination mechanism. Certainly it seemed that the group of friends could be a great platform to advance these issues, and those are aspects that I deal with in the paper and provide some recommendations for, including like really increasing kind of the human resources to ensure that there are the necessary focal points both at HQ and at the mission level, and really this mechanism to share good practices between TCCs. Great, so now we're going to move to our next two speakers, which will provide an operational perspective. We will start with Rafik Maamar. Rafik, I hope you're there. Rafik, you are, yes, we can see you, thank you. Rafik, you are a Commissioner General of Police, and you have been the UNPOL's Head of Criminal Investigations Section at MINUSCA since last year. Thank you very much for being with us. Rafik, we'd love to hear from you, what you can tell us about the type of crimes that MINUSCA is facing, the type of challenges that UNPOL is facing in supporting these investigations, and about your recommendation to overcome these challenges. Thank you very much. The floor is yours.
Thank you, Agathe. Thank you, IPI and Netherlands, for organizing this meeting. So I share with the audience some slides and information regarding the support to the investigation and prosecution of serious crimes committed against United Nations personnel here in Central African Republic. As you see, I start my first slide with the guidance document or the framework that we work with, whether internal documents such as the resolution or the MINUSCA SOP on support to the investigation and prosecution of serious crimes committed against United Nations personnel, and the collection and management of related evidence by the mission. But also you mentioned, Agathe, that in your introduction, the status of forces agreement set between the MINUSCA, and the Central African Republic government. Other documents were also mentioned by my predecessors, the cruise report, the DPO SOP also on investigation, and the action for peace and the action for peace plus priorities, especially priority number 4. As you see, we are maybe one of the rare missions that have each a dedicated SOP on investigation and the support to the investigation given to those crimes. So next slide, please. Yeah. So what is the UNPOL role, the United Nations Police role in this framework? We work on ensuring that all these attacks on United Nations Police and personnel or premises as well are brought to the attention of the relevant prosecutorial or judicial authorities as a systematic, of course of action. But we also actively seek the prosecution of persons responsible for attacking the United Nations, the peacekeepers and personnel. How we do that? It's through a working group that was set in MINUSCA, comprising, in addition to the police component, the Justice and Correction section, which leads this working group, the force and the legal advisor, the mission legal advisor office as well. So all these stakeholders, we work together to try to, of course, provide support to the investigation, but also monitor and do the necessary follow-up for the investigation. In Central African Republic, there are 3 main types of investigation that can be done in the aftermath of a crime against peacekeeper, whether a national investigation conducted by the internal security forces with support from UNPOL, and here we provide whether investigation support, forensic support, but also other kinds of support that I speak about. The second type of investigation or intervention are the investigation conducted directly by the United Nations Police, the police component, under urgent temporary measures to be transmitted later to national authorities. And the third one is a national investigation conducted by the internal security forces without the support from UNPOL. And as I said, the standard operating procedures on support to the investigation provides us with a detailed framework and steps to be adopted in the 3 cases. The investigation, we have the section which I'm leading, the criminal investigation section, that provides support directly, whether in terms of capacity building to the internal security forces, or to assist them also and to work with them closely in doing the judicial act necessary for those crimes. But also we have here a forensic team, a specialized police team that was deployed to MINUSCA, and which is providing also the same, whether capacity building in terms of forensic, but also direct support to ISF for doing the necessary actions, judicial actions for those crimes. The third one, as I said, the urgent temporary measure, which is a specific action for MINUSCA, where there is an absence of ISF or armed forces here in some parts, remote parts of the Central African Republic, or where there are some security forces, but they are not operational, we receive a request from the prosecutor to lead the investigation, the judicial investigation, and to replace the ISF in those remote areas. So on the right, you see as well, we also provide assistance to the national counterparts in terms of the arrest and transfer, and there is a dedicated SOP for that. So the request for arrest shall be processed in accordance with the SOP, with the standard operating procedure on decision making and on apprehension, arrest, and on support to arrest. And this request to detain or to transfer one or several suspects under, of course, we do it under the UTM, the urgent temporary measures, to a location different from that of the arrest, shall also be processed in accordance with the SOP. And for that, there is also another dedicated working group under the lead of Justice and Correction to perform the necessary action for the arrest and transfer request received from the national counterpart. In addition to that, thanks to our intervention with our colleagues from other sections here in MINUSCA, we also provide an insight on situational awareness to be used whether in the analytical part related to the threat assessment, but also as a training in the induction training for the new colleagues coming to the mission. Next slide, please. So the final slide will deal with the challenges and recommendation. Of course, the main challenge that we are facing really is the weakness of the host state institutions, not only from an infrastructure and equipment perspective, but also the knowledge to manage crime scenes, to manage investigation, to do the appropriate work at the appropriate time. We are facing a lot of challenge in this regard. In addition, of course, as I said, to the difficult access to some remote areas that are not only accessible due to their geographic description, but also due to the presence of armed groups, which is itself the main threat to us and to the ISF and security forces here in Central African Republic. Also, mainly another challenge, which is the access to information. When these crimes are done in remote areas, the local population is always afraid of delivering information related to the perpetrators. The rotation, now the challenge from our side, the rotation of uniformed personnel is always an obstacle for continuity of work, and due to the last point, which is the absence of a dedicated database. To the lack of this dedicated database, we always have a negative impact of the rotation of uniformed personnel working as a focal points in terms of the crimes against UN personnel. And I'm happy to hear that the database will be launched, a new database will be launched this year, which may be a good opportunity for us to preserve and to conserve a lot of information and procedures related to those crimes. Our recommendation, of course, information sharing is the main milestone in the prevention process, but also in the prosecution. We always urge ourselves first and the colleagues from our section to interact immediately as it is set in the standard operating procedure for the support to the investigation. We also need to have, through this information sharing, I think, to work more and more on developing a common threat picture in terms of situational awareness. And I know that a lot of work is done in this regard through SAGE and through also other mechanisms that are put in place. We also hope that sound follow-up mechanisms such as this database will be set up as soon as possible to be and to ensure continuity of work, of our work, whether the force or the police as well. The fight against impunity and accountability, I think Stefan already mentioned that. And the most important part, one of the most important part as well, is issuing guidance on forensics standby capacity. I think there is no SOPs whether in MONUSCO or here in Central African Republic. Mali, we may have one draft, but there is no specific guidance on deploying forensic expertise in the aftermath, of course, of crime against UN personnel, UN peacekeepers. So this is all from my side, Agathe. Thank you very much, and the floor is yours. Thank you. This is a nice picture from the center of Bangui. So I wanted to end my presentation with that.
Thank you very much, Rafik, for finishing on a positive note. Definitely, thank you also for sharing about UNPOL's role in supporting investigation for crimes against peacekeepers in the Central African Republic. You mentioned the urgent temporary measures and the specific SOPs to MINUSCA. And both of those are indeed quite specific to MINUSCA's mandate, and we can go back to this during the Q&A portion. And thank you also for mentioning the challenges and concrete recommendation to really advance the issue. I'm sure we'll go back to those during the Q&A. We'll now, from Bangui to Bamako, we'll now turn to Ahmed Ghanem, who is the chief of the Justice and Corrections section of MINUSMA, where Ahmed is in charge of issues related to international criminal law, international humanitarian law, and also following and supporting the proceedings related to crimes against peacekeepers. Thank you very much, Ahmed, for being with us. We're all aware of the difficult context in Mali for MINUSMA. So we're really interested to understand how the Justice and Corrections section work with national authorities to address these crimes. We know that so far there have been only 3 cases of conviction of perpetrators, despite the high number of casualties. I want to ask if it's realistic to expect more progress and what you believe can be done to really support your efforts. Thank you.
Thank you very much. Thank you, Agathe. And first of all, I'd like to thank the Kingdom of the Netherlands and IPI for the kind invitation. It's a pleasure for me to address the participants today and indeed also to welcome such an initiative that I think will strengthen the joint efforts to promote accountability for crimes against peacekeepers. Indeed, there was a reference, of course, to the Security Council Resolution 2589. And speaking first about the situation in Mali, I would like to start by the statistics. And from the beginning of the mission in October 2013 until this moment, we had over 170 fatalities, over 172 to be exact. A figure that is, of course, a reflection of indescribable pain for all those who lost their loved ones, family members, but also colleagues here in the mission, not to mention the number of those who have been injured. If I take the statistics for 2023, 13 peacekeepers were killed, again, demonstrating the high number of fatalities and the very sad reality. This said, I would like to focus very much on the progress that has been achieved since 2020. I mean, you kindly referred to 3 convictions. We have to take into consideration that this is a development that only started in 2020. Before that, for all those years, we had no conviction. Of course, there are the challenges, and I would like to reiterate some of the challenges raised. I don't want to repeat what has been said by some of the colleagues who intervened, just alluding to some of the points. Indeed, the context is similar. We're speaking about attacks and high number of landmines, where it's, of course, very difficult. It's a work, of course, of criminal analysis, but very difficult to find a direct perpetrator. Not to mention the logistical difficulties where these crimes occur in areas with challenges related to extension of state authority, of the state presence, and extension of rule of law. And very often in desertic areas where the convoys pass, but where the whole logistical work of transferring the investigators is very often not able to address the need as well to have a prompt deployment to avoid the loss of evidence. So these are, of course, challenges, but I would, not to repeat, I would refer to challenges raised by colleagues, which are very similar in that context. Now, what has been done? What is the work that has been done? This is where I would really like to focus on the approach that was adopted and how it led in a short time frame to reaching those convictions. First of all, I always like to rate as well that when we speak about convictions, and I will come to that in details, is not the goal per se. For us, it's accountability. So this is closely linked to our support to the justice reform, because the important aspect is that there are trials, there is a thorough investigation and trials in line with international standards, and that rule of law principles are upheld. So as kindly mentioned by my dear colleague Stefan Jean, the action has to be at different levels. Level of advocacy, awareness raising, the level of capacity building and support to the national counterparts, and the internal level at the mission in terms of the internal organization, which is again has been alluded to by Colonel Major Muammar in the Central African context of MINUSCA context, but similar also here in MINUSMA. I will start with the advocacy and the awareness raising. Because I think a very important aspect was the direct involvement of the SRSG as the head of mission and the most senior UN representative in the country in this work of advocacy at the highest political level, with a special and specific emphasis on Resolution 2589. I think certainly this is a first point that was replicated at different levels of the mission with national counterparts, and both at the central level in Bamako and in the region in terms of the advocacy with all as well, not only decision makers, but also the practitioners, namely judges and police officers. So this work of outreach advocacy, I think, was a very important preparatory work that is a continuous endeavor. It's not a one-off activity that is still ongoing, but I think that is very important to laying the ground for the direct work that has been done. The second aspect is the direct support to the national counterparts. And in Mali, I would like to refer to the central institution that was our direct counterpart in that work, namely the Specialized Judicial Unit on Terrorism and Transnational Organized Crime, in French, Pôle Judiciaire Spécialisé. We often use the abbreviation PJS. The advantage is that this is a body with an exclusive jurisdiction for prosecution and investigation of crimes of terrorism, organized crime, but equally war crimes, crimes against humanity, and genocide. The fact that they have this exclusive competence was, of course, of added value, because this covers as well, naturally, crimes against peacekeepers, being crimes under international law, but also being our counterpart on different other topics related to the MINUSMA mandate, including support for the institutions in relation to organized crime and crimes of terrorism. And this brings me back to the important aspect of the importance of always growing connect aspects of our support in general to the institutions and our support to the institutions on the issue of crimes against peacekeepers. Another also flagship initiative that was done by the mission that I think contributed strongly is our support to the national institutions on development of a prosecutorial strategy. This strategy focused on crimes that risk destabilizing the peace process. So naturally, part of our implementation of our mandate and our support for the implementation of the peace agreement. This said, it naturally included, as I mentioned, aspects related to investigating and prosecuting crimes against peacekeepers, being by definition crimes that are committed by terrorist armed groups and that are risking a destabilization of the peace process. So this capacity building on one hand and prosecutorial strategy on the other hand were two, as I mentioned, central initiatives that have been adopted in close cooperation with the national counterparts and that were key for this success, I dare say. And the important aspect that these were institutional type of support that are ongoing and that go beyond the file of crimes against peacekeepers, but are of direct and central importance to this initiative. Of course, the other aspects are related to the logistical support to the national institutions for reaching some of those remote areas. And I would like just again to allude to the internal mechanism. So similar to the what has been done by the colleagues in MINUSCA, we have a working group on the judicial response that is coordinated by our section, chaired by according to its guidelines by the SRSG, who has, as I mentioned, shown direct interest in this work and the internal coordination, and by the SOP on the collective analysis and evidence in 2020, which again facilitated a lot the coordination at the internal level. The result, I dare say, is we were quite proud of that, because in a short period with these measures put in place, we managed in March 2021, on 24th of March 2021, to have the first direct conviction for attacks against peacekeepers. 8 were convicted absentia and 1 directly. I have to say that this was preceded by a conviction in 2020 by a person who confessed laying mines against MINUSMA. But I'm focusing on this one because this was a direct result of the initiatives that I've developed later. And then on 24th of January of this year, there was a 3rd conviction for crimes against peacekeepers for an attack that occurred on the 22nd of February 2019. The important aspect of this trial is that the prosecutor in front of the court referred to the case as an exceptional case given the quality of technical assistance provided by MINUSMA. This was provided by our UNPOL colleagues and by the section in terms of the criminal analysis of the evidence and the judicial work that has been done due to the technical assistance provided. The prosecutor himself raised it as an exceptional example of high quality work thanks to the cooperation of MINUSMA and the Malian authorities. So again, a very good example of how joint efforts between the host country and the mission itself can lead to successful results in a short period. And I would, again, as a final point, highlight that our purpose in that regard was not only the conviction, but to ensure fair trials in line with international standards. So this is why also it's closely connected to our work in general on the support to the judicial institutions. So thank you very much. And of course, I will remain later at your disposal for any questions related to those points. Thank you.
Thank you very much, Ahmed, for your presentation. You mentioned really various interesting points. I'll just allude to a few of them. I mean, you started your expose talking about the risks of IEDs, and I want to emphasize the statistics here, which is really terrible, that in 2022, 50% of total fatalities are from IEDs in Mali, in MINUSMA specifically. So we really here understand the amplitude of the problem, and you mentioned the difficulty of prosecuting those crimes. In fact, the case that you mentioned of confession, which led to a conviction, is the only one so far, as far as I know, of a conviction related to an IED attack. So definitely. Actually, both Ahmed and Rafik provided some recommendations to advance this issue. And here I want to stress also the importance, of course, of prevention, of safety and security, which is part of this overall understanding of a comprehensive understanding and approach to accountability to peacekeepers. You also mentioned very interesting points around the important role of the pôle judiciaire spécialisé, which, as I discussed in the paper, sometimes may raise also some questions regarding around the qualification of the crimes, but I'm sure that our last speaker will help us untangle all those issues. So we're turning over to you, Mona. You have over 25 years of UN experience, including as the head of peacekeeping team in the UN Office of the Legal Counsel. Today you're here as an independent lawyer, and we are really, we discussed the policy and operational issues, and so now we're very eager to hear from you about the legal perspectives on crimes against peacekeepers and the criminalization of attacks under the different frameworks. So thank you so much, Mona. The floor is yours.
Thank you, Agathe, and thanks to the Kingdom of the Netherlands for the invitation to be part of such an important and timely and distinguished panel. My task today, as you just said, is to outline the sort of legal parameters and the legal challenges, as well as some recommendations on the challenges of ensuring an end to impunity and accountability for crimes against peacekeepers. But the law, as you know, is not a la carte. We have to look at the law in all of its in its four corners, as they say. The first is the ensuring accountability, the criminalization, the penalization. The second is recognizing the limits within international law, circumstances and consequences of losing protected status, which we will come to shortly. And third is when we ask for accountability to peacekeepers, we also have to ask for accountability of peacekeepers. So this is sort of the broader outline of what we'll discuss in the next few minutes. But as all of the prior speakers have from firsthand experience attested to, the Council expects UN peacekeeping forces to conduct robust operations in increasingly hostile environments where often there is no peace to keep, including against named armed groups like the M23 in the DRC, in self-defense against terrorists and insurgents in places like Mali and Central African Republic, and also for the potential of becoming parties to the conflict through asking that we provide material support to government forces and to parallel forces in the countries in which UN peacekeepers are deployed throughout the world. The rising death toll among UN peacekeepers is a function of the circumstances and consequences of such engagement in such environments. As far as the international law is concerned, the UN peacekeepers are indeed presumed to be protected persons, and any direct or intentional attack on them is indeed a violation of international and often as well as national law. But the protected status is not absolute and may be lost under the circumstances we will discuss shortly. Attacks on UN peacekeepers are criminalized under several instruments of international humanitarian law, under UN Security Council resolutions, and as I just mentioned, under the national laws, which is reflected in the SOFAs and other relevant UN instruments. The intentional attacks on humanitarian actors and peacekeepers are equally violations of the Geneva Conventions. War crimes under the Rome Statute of the International Criminal Court include intentional attacks against the personnel, installations, units, and vehicles involved in any humanitarian assistance or peacekeeping mission authorized by the UN. Similarly, the Convention on the Safety of the UN and Associated Personnel criminalizes attacks on UN operations as well as on their personnel, premises, vehicles, as well as threats, attempts, or participation in acts of organizing or ordering such attacks. But these instruments also recognize that the protected status of peacekeepers is not absolute. The UN Bulletin, STSGB 1999-13, recognizes the applicability of IHL to UN peacekeepers, but recognizes that UN peacekeepers may lose that status in situations of armed conflict when they're actively engaged as combatants and to the extent and for the duration of their engagement. The Rome Statutes accords protected status, but only as long as they remain entitled to the protection given to civilians under international law of armed conflict. And by its own terms, the Safety Convention does not apply to UN operations authorized by the Council as an enforcement action under Chapter 7 of the UN Charter, and where the personnel are engaged as combatants against organized armed forces and to which the law of armed conflict applies. It is not clear whether this is limited to Chapter 7 peace enforcement operations or whether it also applies to peacekeeping missions with Chapter 7 authority to use force beyond self-defense. The increasingly hostile environments, as well as the changing nature, intensity, scale, and duration of UN military engagement in the past decade has triggered at least one mission, MONUSCO, where the mission has lost its protected status under IHL, as recognized by the United Nations. This is, as we said earlier, one of two possible scenarios of losing the protected status, either through sustained or large-scale military engagement, as we saw with MONUSCO and the M23, and or by providing material support to the military operations of the host country forces or parallel forces on the ground, as we see in all three of the missions discussed today. Moving beyond IHL, the Security Council has penalized attacks on UN peacekeepers under Chapter 7 sanctions resolutions, including the 2589. And the Council has called upon all parties to respect international humanitarian law. It has condemned any and all attacks against peacekeepers. It has emphasized that those responsible for such attacks must be held accountable and has imposed sanctions on individuals and entities who plan, sponsor, or participate in attacks against UN peacekeepers. The Council's prerogatives under Chapter 7 to impose sanctions against attacks is separate and apart from the criminalization of such attacks under IHL and is often regardless of whether they are war crimes under IHL. In the same manner, states have the sovereign authority to criminalize attacks by armed groups on UN forces as well as on their own national armed forces, not as war crimes under IHL, but as ordinary crimes under their national laws. So this brings me to the recommendations for strengthening the UN legal framework. The first, of course, is the need for clarity and transparency, the recognition that there is circumstances and consequences for when UN forces become parties to the conflict. It is important that the Council, that the TCCs and the UN troops are aware of those circumstances and consequences, train for them, and are acknowledging the impact that this have on the legal framework. The differences in some of the instruments can cause confusion, dangerous confusion, as we see that there's differences between the UN and the ICRC as to when the protected status can be regained. The UN says when the hostilities are over, the ICRC says when the conflict is over, which could potentially two different things. The statute of the Rome Statute and the Convention on Safety also have differences in terms of when the exception applies, when the loss of protected status occurs. So these are important things that have to be clarified, not only for the Council and member states, but specifically for the TCCs and the troops on the ground, so that they know what they're getting into. The Secretariat should therefore update the 1999 bulletin, and the DPO should institute dedicated legal and operational training on these issues. Last but not least, it's important to recognize that when the mission becomes a part of the conflict, it does inherently become a threat to the very civilians it is meant to deploy. The very civilians it's deployed to protect. So when the mission is at risk of becoming a part of the conflict, or has become, as in the case of MONUSCO, it needs to be very careful about its positioning, about its proximity, as well as its presence, because by virtue of becoming a legitimate military target, it thus becomes a threat to the very civilians it's meant to protect. And they then become collateral damage to a legitimate military target. So all of this above reinforces the adage that the UN Secretariat has long maintained, that the Security Council should be wise to heed that UN peacekeeping missions should not be established to wage war, but rather to make peace. And doing the two at the same time is a big challenge. And as such, UN peacekeeping operations should remain a force for peace and not a force for war.
Thank you very much, Mona, for reminding us the legal frameworks and the contour of the discussion. You pointed out to the differences in the legal approaches and really called for those to be clarified. This is a recommendation that I share, and very aware that this is a sensitive discussion, but which I personally believe that needs to be held to really reinforce also accountabilities to troop contributing countries and to peacekeepers in general. So, I mean, with that, thank you so much to all our panelists. We're now gonna turn to open to the discussion segment of our event. We have a bit less than 30 minutes. I will start asking the first questions, but so that you have the time to prepare for yours. I'll be monitoring the chat online as well as, of course, the audience. So please feel free to raise your hands. So again, thank you to all our panelists. My first question, I'll ask two, and then please feel free to let me know who'd like to answer, is that something that was redundant in the research is that we saw that really one of the biggest challenges is the sometimes weak consent of the host state, at least apparently. But unfortunately, under the discussion and for the 3 priorities missions that we are discussing, this is potentially where host state consent is under most stress. So how can the UN really manage the political and strategic implications and advance accountability for crimes against peacekeepers at a time when peacekeeping faces a crisis of consent? This is my first question. And the second one is about the fact that there are a few important actors that we actually have not mentioned today in the discussions. And those are the victims themselves, the families of the victims, and civil society actors. So I'd like to ask you how you believe they should be involved in accountability processes and what their role should be in this issue. Thank you. Let's see who'd like to take the floor to answer. Would like to?
Yeah.
Stefan, please go ahead.
Thank you very much, Agathe, for raising these very important questions. So maybe some preliminary remarks, and I believe perhaps our colleagues that are present today and from MINUSCA and MINUSMA would be best placed to discuss about issues of consent. But certainly as an overview, and certainly based on my experience over the past years and dealing with this issue and working very closely with our colleagues in Kinshasa and Bamako and in Bangui, I would say the major challenge is not so much overall issues that may be related to a crisis of consent with the host states, but rather almost in all instances, issues related to capacity or operational challenges and the investigation and prosecution of these crimes. Firstly, some of these challenges were mentioned today. Sometimes, yes, national authorities may, in some instances, face a certain number of priorities, which may have an impact in terms of their overall prosecutorial strategy, and we've discussed about that. But I wouldn't say that the consent per se has had a significant or major impact on the opportunity to prosecute and investigate these cases. Again, it's primarily related, at least from our operational experience, to the fact, again, that these crimes are often committed in areas where local law enforcement agencies and local institutions are not present. Literally, they are not present. And these areas are often under the control, partially or totally, of illegal armed groups. So that's the first thing. The second thing is that in terms of the operational capacity of those states to investigate and prosecute, and some of the challenges were mentioned in terms of securing and handling material evidence, in terms of the protections of victims and witnesses. Often these victims and witnesses, or witnesses to be more specific, are in areas where they might be subject to duress or threats from armed groups. So it's essentially how to address that, but I think my colleagues and MINUSCA would be, and MINUSMA would be best placed to answer that. And I don't know if our colleagues from if we have online representative from the Congo and Mali and the Central African Republic, I think they would be best placed also to comment on this issue. Secondly, in terms of victims and witnesses, indeed, we have procedures in place, and this has existed for quite a while, in terms of claims, in terms of reimbursement, in terms of compensation for the families of these victims. And this is a system that is, I think, well established and recognized and supported by member states. We've also had cases more recently where under this is more in civil law jurisdiction, I'm thinking about the word in English now, but partie civile, where in some instances, the families of the victims have this opportunity to become civilian parties to the prosecution. However, this is an area really where much more needs to be done, much more needs to be done in terms of guidance, much more needs to be done in terms of the interactions with the families of the victims. So this is certainly as part of our agenda, and we're approaching that. And this is something that we're going to look at also as part of our forthcoming strategic action plan. That's it from my side. Thank you.
Stefan. Checking whether the other panelists would like to take the floor at this moment.
If I may.
Yes, please.
Thank you, Stefan, for covering this quite comprehensively. I just have one thing to add. When we talk about ensuring accountability and the host state's consent, we should not forget the role that the mission has to play in this. The political synergy between the mission and the host state is extremely important. It depends on the relationship that the mission has with the host state as well, which gives it the political will as well as the, I would say, the encouragement to pursue accountability. Thank you.
Thank you. Go ahead, Ahmed. Yeah.
Yes, thank you, Advisor. Thank you. So just on those 2 points, indeed, in Mali, when it comes to consent, actually there was only a very strong and close cooperation with the national counterparts. So I mean, no concern met there at all. There was a clear commitment to supporting the file. I wanted to raise my hand because of the question of the participation of the victims, and Stefan alluded to some of the points. We indeed started that process for the recent verdict that I mentioned in my presentation, which took place on January of this year. The idea was to have their participation. Logistically less complicated, so we suggested that they're connected remotely, and I think this would have been a very important point. Gladly also the national authorities welcomed very much that point, and so that just to bring it as another example also of cooperation and the first initiative in that regard. Unfortunately, this was not possible due to purely logistical reasons. And I think, as kindly mentioned by Stefan, I think it's important that we have more guidelines and more established practices. Very often this goes through the member states and the permanent mission to connect them. So the contact is not very often direct, and this complicated and caused delays in arranging for the logistical connection. But our idea, and we will make sure for the next possible trial on a case of attacks against peacekeepers, our intention is clearly to connect families of the victims as an important, also, I think, symbolic aspect of serving justice in relation to families of the victims. Thank you.
Thank you very much, Ahmed, for mentioning this really important and interesting example. So we have a few questions online and also in person. So please, actually, sir, please go ahead in the middle if you like.
Hi, good morning. My name is Oscar Solera from the Office of the High Commissioner for Human Rights. Thank you, Stefan and Colonel for the presentations, colleagues as well in further locations. I have a couple of comments and a question as well, or a remark more than a question. I think your question I got in relation to victims and to witnesses is key. And I think we need to remember that the question of accountability is not just the question that it's within the realm of the international community. We're dealing with criminal procedures. So it's not what the UN or the international community can offer, but it's also what at the national level, national justice mechanisms can offer to ensure, one, the participation of victims and witnesses and families, but number two, what are the mechanisms to protect witnesses when they participate in the criminal proceedings. And I think what we see often in these places is that there is no witness protection program. So it cannot be expected that the mission will protect witnesses that will participate in these proceedings. And part of the push that we need to also ensure when we talk about accountability is to ensure that both witnesses and victims or their families are duly protected if they're participating. Not just that they can participate, but it's also that they are protected from reprisals, because of course we know who are the actors that are committing these violations. Number two, I think we need to remember, and it was mentioned before, but I think it's important to recall, we're talking about perpetrators, we're talking about fair trial and due process guarantees. Now, in many of these countries, there is no legal aid program. So legal representation is one of the key elements in the fair trial. And I think part of what we need to ensure is that we cover that part of the equation as well, that we are also supporting the creation of legal aid programs for alleged perpetrators of the violations. Three, we need to be careful when we talk about accountability for peacekeepers, not to be creating a perverse two-speed justice system. And I think there's a fundamental risk. We see interesting examples. Ahmed talked about the support of the Pole Judiciaire in Mali. But what happens with the rest of the system? We are, in fact, creating a two-speed system where we are ensuring accountability for acts committed by terrorists, but not necessarily supporting in the same measure and with the same results access to justice for all, for other violations. And I think we need to bear that in mind. One minor point, and then that is that we need to also be careful when we support judiciaries when they impose death penalty for perpetrators. And I think that's a no-no for the UN. Finally, the question goes, I think more and more we see in Mali and CAR, but also in other places. Perpetrators are not just terrorists. And we see with deployment of private military contractors in Mali and in CAR, that while they are still somehow, or we say the UN has been saying that they are affiliated with national governments, they don't necessarily are subject to national accountability mechanisms. That is, they may have amnesties or clauses that exempt them from national prosecution. And it could happen that perpetrators are members of these private military contractors. And so this is something that we need to think of also in terms of how are we going to address and resolve that. Thank you.
Thank you so much, Oscar, for your intervention. Yes, I saw a gentleman here. Oh, no, you wanted to. Mona, I'll give you the floor right after. Thank you.
Thank you. Thank you very much. My name is Mirko Andrek. I'm Deputy Military Advisor at the Swiss Permanent Mission here. We heard before it was said very eloquently that when peacekeepers are or become are party to an armed conflict, attacks on them do not constitute war crimes or international crimes. But at the same time, I think we also need to bear in mind that in non-international armed conflicts, there is also no protection from prosecution for the attacker. So these can still be brought to justice under national law. So my question is, well, whether I think Mona could expand on this. And secondly, has this played a role, or how has this been dealt with in this case in MINUSMA that was mentioned before? Thank you very much.
Thank you. I'll take another question and then I'll move to the panelists. Thank you.
Good morning, everyone. I am Brigadier General Sadek. I am Milad and Polat, Permanent Mission of Bangladesh. First of all, I like to thank IPI and Kingdom of Netherlands for organizing such a time-bound and required workshop or seminar, that is accountability for crimes against peacekeepers. Bangladesh is present in all three missions that you named today: the MINUSCA, Central African Republic, MONUSCO, the DRC, and also Mali, MINUSMA. And we provide 7,500 peacekeepers as on today, and being the top TPCC at present. So we are mostly affected because of this ID action, and this is our also demand that accountability for the peacekeeper should be ensured. And the forum that India led, we are also one of the co-host or co-sponsor. Madam, today I have many questions, but still for the time constraints and for legitimacy of the discussion, I will start to a few points and some queries also. The first one is that the IDs, these are not the product of the countries of MONUSCO, MINUSCA, and MINUSMA. So is there any investigation that you find out the sources that from where such military value things are being used by the criminals and which are used against the peacekeepers? This is first point. The second point is that for taking a case forward for proper justice and prosecution, the proper investigation is very important. So we find that once an incident takes place, the crime scene is not being protected. Whose responsibility of the protection of crime scene, which is a fundamental thing to find out the informations, and then how the investigation is done. Is it the only UN takes the investigation, or it is the host country investigation, or it should be a dual investigation? Because basing on the investigation, you can try the identify the criminals and finally try them. And last but not the least, does the legal framework is enough to try so many parties involved in the criminal activities, like host country, then UN, then troops contributing country? So is that legal issues or legal framework is sufficient to deal for the criminals to be brought into the justice? Thank you so much.
Thank you very much, sir, for these important points. Actually, online, we have a number of questions that is similar to this one, meaning when we see the challenges that exist at the national level to prosecute those crimes, then we can wonder whether there are alternative jurisdictions perhaps either at the other national levels, for instance, from the countries of TCCs, or at the international level to prosecute those crimes. So this is the question I wanted to add. So lots of great points. Thank you so much. I'll turn to our panelists. Mona, you wanted to take the floor. Please go ahead. Mona, you are on mute.
Thank you, Agathe. I will start with the last question first. The question was whether the legal framework is adequate. I believe that it is. Oftentimes, it's not that the absence not only of law, but also of very robust policies that the UN has, but it's a lack of awareness, and it's a lack of application, and it's a lack of enforcement that is often the problem, not the legal framework itself, which I do believe is adequate. As far as the question by the Swiss, I fully agree. I think I stated that separate and apart from the IHL criminalization, there's also the penalization by the Security Council, and the prerogatives of the Council go well beyond the limits of IHL, as do the national laws, which allow for the prosecution of ordinary crimes, even where the act itself is not a war crime. This also raises the question of the human rights aspects. That the first person who asked the question, I wish to applaud that person for raising very many issues. Indeed, the UN applies international human rights principles as a matter of policy, and as such, it must be concerned limits on its cooperation with judicial proceedings that do not, criminal proceedings that do not afford the minimum human rights standards, including due process, including fair trial and humane treatment of the defendants, as well as, of course, protections for witnesses and victims, of course, and they're involved in the criminal proceedings. More controversially, the UN has a categorical policy on not cooperating with criminal proceedings, that the death penalty, where the death penalty applies in the event of a guilty verdict, and that also needs to be recognized and respected. But there's also the operational consequences of these IHL and human rights constraints, which is the actuality as well as the perception of becoming a party to the conflict interferes with the mandate itself often. And the more akin to a party to the conflict, the armed conflict, the mission is, the less able it is in some cases to deliver on its other mandates, providing protection to humanitarian actors who may not want the proximity to forces that are now perceived as combatants. The victims of humanitarian law violations and human rights violations may not feel comfortable coming to the UN when they see them as a party to the conflict. So these operational implications, it's more than just the ideals of the legal framework. There are practical and operational implications that must be addressed. The perception of the mission when it commits violations, when its personnel are committing violations, either of law or of SEA policy, also matters. And therefore, our practicing what we preach is very important, that we not only call for accountability, but we hold ourselves accountable when we are in breach of those frameworks.
Thank you very much, Mona. Okay, other panelists would like to take the floor. I'm thinking, Ahmed, you may be interested to chime in on some of those questions. Or Rafik, also on the IEDs questions.
Yes, if I may.
Please.
Okay, thank you very much. Yeah. So I'll ask the last question regarding the AIDs and the crime scene. First of all, let's say that the primary responsible for the protection and security of the UN personnel is the host state, and for the investigation is the host state. So it's their primary task and primary responsibility, as I said, and we do not intervene unless we have a request of support from the national authorities. And this is what I mentioned in my expose. There are three kinds of investigation. One conducted by the internal security forces without the support of UNPOL, or with the support of the police component, or under urgent temporary measures. So, and I can say that now we are following some cases that came back to 2014 and 2015, since the establishment of MINUSCA, and it's really a problem when the national authorities or the internal security forces are conducting the investigation by themselves because of the weakness in their capacities and capabilities to make a right follow-up and to go ahead, to go forward with the investigation. This is a real problem for us. It's true that we are still monitoring those cases, but a lot of evidence has disappeared. A lot of testimonies, we don't find the accurate person. So a lot of discrepancies in the judicial process when conducted by the internal security forces by themselves. And this is the kind of support that we are always providing and try to provide in terms of capability buildings or in terms of supporting directly the investigation. For the EID's traceability, I think the UN has different mechanisms. I can mention one, which is the group of experts on weapons and the embargo, and it's part of their work also to make the traceability, and there is direct communication between us, the different stakeholders, and the group of experts to provide them with the right information. So I hope I answered the question. Over to you, Agathe. Thank you.
Thank you very much. Yes, Rafik, you're still with us. Ahmed, if you'd like to comment.
Yes, just on a small point related to points raised by on the human rights aspect. Indeed, as I mentioned in my presentation, conviction is not the goal per se. When we speak about accountability as a goal, in the sense we would like thorough investigation and prosecution to be conducted, but it's important that we have fair trials that meet international standards, both human rights and rule of law standards. And this is an important point that I highlighted, and this is why it has to be coupled with, in general, support to the justice issues. Now, on the prosecutorial strategy, should not be misunderstood. I mean, when we say there is an advantage of a central authority, that where there is a concentration of support in relation to this topic of attacks against peacekeepers, but the prosecutorial strategy is an initiative where we provide support to the Ministry of Justice as a whole and the entire judicial body, meaning it addresses other topics, of course, especially crimes related to the, as I mentioned, destabilizing the peace process and other types of crimes that are not directly necessarily related to the crimes against peacekeepers. So just not to avoid any confusion on that point. Thank you.
Thank you very much, Ahmed.
Thank you very much. Just concerning the important point raised by the representative of Switzerland, definitely in all the cases that we've been looking at, the applicability or not of IHL has not been really a substantive issue in terms of the way these cases are being prioritized by the national authorities. From a doctrinal perspective, the approach that we have had as part of our standard operating procedure is to focus on what we call serious crimes against peacekeepers. For our purpose, this is defined as cases essentially of intentional homicide or manslaughter. Secondly, a case of kidnapping or enforced disappearance, attacks against person causing or to cause physical harm, rape and other forms of sexual violence, and any attempts or threats to commit such crimes against our personnel. So this is the overall doctrinal approach, which is essentially based on the qualification of ordinary crimes under national jurisdiction, whether in the Central African Republic, in Mali, or in the Congo. There's no real discrepancies, I would say, in that regard. Now, from a policy perspective, what we have decided basically from the onset to do is that in order to achieve what we want to achieve in terms of dealing with impunity, we needed to be very focused for a certain number of reasons: political, operationally, resource. So therefore, we focus on these three missions where most of these fatalities have happened since 2013. We focus on cases of fatalities as a result of malicious acts, which is essentially intentional homicide, not on the other categories. This doesn't mean that in the future we will not focus on these categories. We have an incremental approach. And that's why certainly working and supporting our national counterparts in these three countries, we were able to go from 0 to, I mentioned 70 conviction, although I fully, of course, agree with the points raised by my colleague from OECHR and colleagues in MINUSMA. But the results, basically, these results were achieved because of that focused approach to this issue, which we will continue, but also expand to other peacekeeping operations, as well as for other crimes also in the future. Thank you.
Thank you, Stefan. Thank you so much for everyone. So we are actually, I see that we are already after time. So, I mean, I want to really thank all our panelists, Stefan, Colonel Bala, Rafik, Ahmed, Mona, thank you so much for sharing your expertise, your experience. This has been a very rich discussion. And thank you to the Netherlands. Thank you to all of you for being here online and in person. I would really encourage you to stay in touch, to read the report that is available on there and also online on our webpage. We love your feedback. And so thank you so much for being here, and thank you. Have a good rest of the day.